Hello everyone. So we are here to give presentation on business and corporation law, and let me first introduce you all with to you all with my group members, starting with Bimal, Bharat, Susan, Nisant, and me myself, Ashmita. So our presentations, our report, it consists of like two parts, part A and part B. Part A is contract law, and part B, it consists of the corporation law. So further now, let's start with the part A, which is contract law. And we have selected the Alex, who is a property developer, and he owns a blocks of land, and his intention is to build 10 apartments, subdivide it and sell it. Alex is very keen to commence the construction. Under the contract, he has the right to start the work before the contract. But he fails to mention his lawyer. But later his lawyer he comes to know about what Alex failed to inform him by usual search. Alex has just obtained certificate that the land is joint residential, and which is contrary to the certificate which was issued by the city of Williamstown only a few months earlier. So now we have to advise Alex regarding the right against the vendor, city of city of Williamstown, and his lawyer. So now I'd like to introduce my friend Bimal, who will give you more detail and he'll give you more explanation about this case regard and he will explain you more about the issues and rules and what were the problems and all. Thank you.
Introduction and brief explanation of case. So I'm here to explain about the issue and rule of this case. So first of all, we have found two issues after the group discussion. So one is the city of Williamstown liable for Alex, and another is Alex lawyer liable for Alex. So these are the two issues that we found out after the group discussion. And for the rule, we have three rules. One is the fraudulent misrepresentation, another is innocent misrepresentation, and the last one is negligent misrepresentation. So in fraudulent misrepresentation is an intention to deceive the other party, this including the contract, where the innocent party suffers the loss and the victim will have the rightful remedy in the third. And another one is the innocent misrepresentation. So it is the representative here. Representative makes a statement believing it to be a true and has no intention to deceive the representative. We can also find the innocent misrepresentation from the case of Whitington versus C.L. Hain, 1990. And the last one is the negligent misrepresentation. And it is any false statement made by an owing fiduciary duties to another, and by an expert making statement about matter related with their expertise. Thank you. And for the replication, my friend Susan will describe it in a brief. Thank you.
Thank you, Bimal. Myself, Susan Tungel, and I'm here to represent some relevant application on this scenario. As mentioned by my friend Bimal, now this is the case of misrepresentation. Here, city of Williamstown won fiduciary duty to plaintiff Alex. It seems that it failed or was negligent to check on the reliability of the representation made, and the basis for an negligent misrepresentation satisfied in here. So according to lawyer perspective, lawyer-client is a special relationship where silence is not acceptable. Therefore, the lawyer was bounded to inform Alex about the change in circumstances, whether or not Alex had told him about the work being commenced. As a result, Alex's right to claim damages under the tort of negligence and resides, the contract is lost. They suggest that the plaintiff was not included into the contract just by the misrepresentation made by the city of Williamstown. This makes the contract voidable. Thank you. Now I would like to invite my friend Bharat to conclude this case. Thank you.
Thanks, Bharat. Now I'd like to present the application and conclusion of the problem question of the assignment. First of all, I like to give the application of the question. The company need to be registered as a proprietary company. In this case, the classification of the company is according to the anticipated public status of the company as lacks information of the members' liability. And the second thing is, by the end of the 5th year, it satisfies two tests. First one is the 13 million assets and the second one is 26 million revenue. To be classified as a large proprietary company 45A, the change in company type should be commenced. And the last one is Corporation Regulation 2001, prior consent from the Minister of Veterans Affairs to use the words Anzac Coffee. To conclude, initially the company should apply to register as a small proprietary company, but by the end of the 5th year, as the company seems to be a meet criteria for a large proprietary company, it needs to change its company type accordingly. The use of Anzac Coffee in the company name can be possibly changed from Minister of Veterans Affairs, and it must change and include the proprietary or private in its name. And I like to say that the references are from the act as well as from the book. Thanks.
Good afternoon, everyone. Thanks for the previous presentation. So, on our I'm going to explain about the part B. So we have on part B we have the corporation law problem. So the problem is as follows: you have discovered a low cost way to brew a coffee at home without using a expensive coffee machine. You want to form a company which consists of only your family member, and you wanna give the company name as Anzac Coffee. And at the end of the first financial year, the gross asset is $5 million, and with the 20 full-time employee, and the gross asset of the first financial year is 10 million, and by the end of the 5th financial year, the company have the assets of 13 million and the employee 5 full-time staff and 63 part-time employees, and company have the assets of 26 million at the end of the 5th financial year. And the issue on this case is what type of company should be registered with ASIC, and how will the company be categorized under the given condition for the 1st and 5th year. And the third issue is, can the company use Anzac Coffee in the name of company? And the rules for this case is a proprietary company under the Corporation Act 2001 often are family companies sized small or medium. It needs to have at least one director as section 201A, and needs to use the word proprietary or Pty limited in the name section 149(1). And the other rules is small proprietary company gross operating revenue of less than 25 million for a financial year, consolidated gross assets of less than 12.5 million, and employee less than 50 full-time employees, section 45A. And the large proprietary gross operating revenue of more than 25 million in one financial year, and more than 12.5 million of dollar gross assets at the end of the financial year and the employ 50 or more full-time employees. To be classified under any of these category, a company needs to satisfy any of two tests. So that's all about the issues and the rules, and the application for this case will explain by my next presenter, his name is Nissan, and it will be continued. Thank you.